Okay, and again, welcome to this evening's presentation of part 5 of How Wealth Rules. And we'll be covering the chapter that's titled The Emancipation of Property from Democracy. And we'll start out, as I mentioned, with a quote from Franklin Roosevelt that kind of sums up the tenor of the political situation that we'll start with in these two stories that I'm going to tell you. And what the purpose behind some of these machinations were. So here's Franklin Roosevelt, quote, "Out of this modern civilization, economic royalists have carved new dynasties. The royalists of the economic order have conceded that political freedom was the business of the government, but they have maintained that economic slavery was nobody's business. It was natural and perhaps human that the privileged princes of these new economic dynasties, thirsting for power, reached out for control over government itself. They created a new despotism and wrapped it in the robes of legal sanction. And as a result, the average man once more confronts the problem that faced the Minutemen." End quote. So we see President Roosevelt expressing real concern about what had already taken place in his day. The insinuation of large quantities of money and wealth into the political system, and essentially the overtaking of government by wealth. So in this chapter, the first subheading is called Privatizing the Village, Pulling the Rug Out from Under Us. The courts have transformed the contract clause of the U.S. Constitution from a safeguard of bilateral business agreements into a pry bar for ripping municipal governments out of the hands of local communities. As more of what was once considered in the public domain is given over to the private sector, democratic power diminishes in proportion. More of what once was the society-wide concern is transformed into a business concern, beyond deliberation and control by public law. This is what the enclosure and privatization of law and government looks like. The Supreme Court laid the groundwork for privatizing local governments across the U.S. in 1819. All it took was for Chief Justice John Marshall and fellow Associate Justice Joseph Story to invent a legal distinction between private and public corporations. Inventing this distinction with no precedent to rely upon made it possible to declare every municipal government in the nation the property of the state in which it is located. It allowed the courts to rule that the people have no right to use their municipal governments to make enforceable laws that serve the interests of their communities. Marshall and Story are responsible for the legal sophistry that tempts us to believe that local governments have no authority to protect the people. The distinction between public and private corporations I'm making is not at all related to publicly traded versus privately held business corporations. We're familiar with those terms. We hear folks from Wall Street talking. It isn't about that. Both the publicly traded and privately held business corporations are what Marshall would categorize as private corporations, in that they are chartered by the state and there are owners who receive the charter. There are particular people who invest in the corporation and they receive the charter from the state that issues it. John Marshall, a member of the Federalist Party and protege of Alexander Hamilton, was appointed Chief Justice of the U.S. Supreme Court by John Adams at the end of his term in office in 1800. To deprive the succeeding president, Thomas Jefferson, an anti-federalist, of a Supreme Court appointment, Adams took advantage of the Midnight Judges Act, passed hurriedly by Congress. It authorized the reduction of the Supreme Court from 6 to 5 members. And so we see it wasn't always 9 members, and that is changeable. Justice Joseph Story was appointed to the court by President James Madison in 1811. Also a strong Federalist, He would tag team with John Marshall to prove his ideological allegiance to wealth and opposition to democracy. According to cultural historian David Burrion Davis, Judge Story saw the pushback against the Federalist counter-revolution under Andrew Jackson's presidency as oppression of the wealthy minority's right in property by a government representing the majority of less wealthy men. R. Kent Niemeyer, professor emeritus at the University of Connecticut and professor of law and history at the University of Connecticut School of Law, wrote that, quote, consolidated wealth sufficient to underwrite large-scale economic projects did not exist in the early 19th century. For the state to bestow economic prerogatives on select individuals would be to create a privileged elite, which was antithetical to the principles of Republican equality. For the state to extend corporate status, sovereign power, and economic privilege to associations of individuals, however, was a solution which satisfied both economic expediency and Republican ideology. This was reflected in the phenomenal growth of business and corporation during the first 3 decades of the 19th century. And so rather than creating an aristocracy based on individual privilege, the point is that Niemeyer is making is that they made those privileges apply to associations as in corporations. Corporations chartered prior to the revolution by the king still existed. Dartmouth College in New Hampshire is the example in our sights. It was chartered in 1769 to serve as a kind of finishing school for the colony's well-to-do, but also to train Native Americans to accept absorption into the European culture. Thomas Jefferson. Yeah.
Can I ask you about that? How did it do that to the Native Americans? In other words, some of them were sent to the school, were allowed.
It was select. It was select members of the Native American population. It wasn't as though a lot of folks were going. No, it was just a few select people. Right.
The elite.
Well, I don't know if they were elite, but I think that more likely they were the folks that that the colonizers hoped they would be able to sway into supporting and become examples and really spreaders of the way of thinking, the mindset of the European culture. Okay.
Yeah. Okay.
All righty. And so Thomas Jefferson's friend, the governor of New Hampshire, William Plummer, he proposed that the school's charter, that's Dartmouth, be changed to make Dartmouth a state college rather than a privately run institution. The idea was to make Dartmouth the nucleus of a statewide system of public education. He went to the state legislature and asked them to draft the legislation necessary to make the change. They agreed, and soon Dartmouth became a state college with a charter that no longer enumerated privileges once granted by the sovereign king, but now placed the school under the command and the sovereign people of New Hampshire. The trustees of the college objected. They took their case to court, claiming that the king's grant of a charter was between them and the king, and none of the business of New Hampshire or its citizens. Eventually, the New Hampshire Supreme Court ruled that the legislature had acted with full authority to change the terms of the corporate charter that created Dartmouth. The sovereign, that is, the people, retained their power to command the creations of their laws, and that includes corporations. As you might guess, the trustees weren't satisfied. They appealed to the federal courts, and eventually the case reached the U.S. Supreme Court. The bizarre rulings of the court in this case set the stage for the Federalist counter-revolution to really take off, branch out, and lay the foundations for our modern crisis of government. The Federalists had a keen interest in the outcome of the Dartmouth case. They saw it as the opportunity to free the private interests of industry and capital from democratic oversight. This outcome was on Chief Justice John Marshall's mind, It was on Associate Justice Joseph Story's mind. They were looking for a legal argument that would reshape corporations as vessels of privilege for the propertied class. Freeing them from the purview of public law and placing them in the realm of private law was the best course of action toward this end. But no precedent existed to justify the desired outcome. R. Kent Niemeyer lays out the situation this way, quote, "The corporation, all agreed, was a creature of the state, an artificial being, invisible, intangible, and existing only in contemplation of the law. But having been created by law, a fundamental question had to be answered. Would the corporation derive its legal rights by analogy to the individuals who comprised it, or from the public authority that created it? If the former, then the corporation, in addition to the power accrued by its associative character, that is, would fall heir to the impressive body of property rights given to individuals by Anglo-American law. If the latter, then the state could control corporate power in the interest of the public. The practical motivation for freeing private incorporated business from the governance of their state creators had to do with the aspirations toward commercial expansion and continental expansion. Neumeyer hinted at the negative impacts on the general welfare when he wrote that, quote, "To free the corporation from state regulation would obscure the impact on the public of these new concentrations of political and economic power," end quote. Marshall was able to cut the Gordian knot that constrained business corporations to the authority of the states that chartered them with an unprecedented bit of legal creativity. He conscripted the Constitution's contract clause to his aid, and according to Niemeyer, was able to conclude that, quote, "A state charter to a corporation was also a contract within the meaning of the contract clause of the Constitution. The consequences of this decision were immense. The new business corporation came under the protective mantle of the Constitution. The tendency to define corporate rights by reference to the authority that created them was silently abandoned. Assured of this protection, capital flowed into corporations, ensuring their preeminence as vehicles of economic growth." And so this is really the first instance of the Supreme Court discovering corporations in the U.S. Constitution where they're not mentioned at all. And it is also a decision to turn the courts back on the authority of the people to govern the creations of their laws, the corporations. In a concurrence in the Dartmouth case that went far beyond what Marshall's arguments proposed, Justice Story offered an expanded thesis on the new arrangement. Not only would the charter creating new business corporations become, instead of a grant of privileges from the sovereign people, a contract, Justice Story went much further. He invented two classes of corporations, one for the peasants and one for the gentry. So not only did they create private and public corporations, they decided to talk about public and private contracts. So the contracts clause was applied to the corporations. They went beyond that and they said, we're going to create a couple of different types of corporations and they will have distinctly different powers and authorities. Without precedent from American courts or the British common law, Judge Story declared that while business corporations would enjoy equal status with the state that creates them as partners in a mutual contract, quote, "The public corporations are such as exist for public political purposes only, such as towns, cities, parishes, and counties," end quote. Corporations like the City of London in England, that under English common law had the same status as the British East India Company, arguably a business corporation, would have a different status in the United States. The new municipal corporations would be state-created subunits having no contractual relationship with the state and utterly subordinate to the state. Judge Story saw an opportunity to magnify the status of business corporations by deflating the status of his newly defined public corporations used by the people to govern their local affairs. Under his novel theory, only with state permission could municipalities challenge the power of the state's contractual partners, the wealthy private corporations. You see what we're getting at here. If the corporate charter of a business corporation is a contract between the state and the incorporators, then according to contract theory, neither party can unilaterally change the terms of the contract. And so the state can't rein in what the corporation is doing once it has signed a contract with the incorporators. Now, the second part of this decision that Story added, Justice Story said that the charter given to private business corporations would no longer represent privileges bestowed on the incorporators by the sovereign people. Going forward, the so-called private charter would be a contract between the state issuing the charter in the name of the people and the individuals receiving it. The incorporators would have legal agency to govern the corporation independent of state control. So they were like little sovereignties all their own, chips off the old block. Importantly, since the charter was now a contract, the state could not unilaterally alter the internal affairs or revoke the self-governing authority of the business corporation. The same cannot be said for public municipal corporations or the rights of unbanked citizens to govern themselves. The state, increasingly swayed by wealth concentrated in the corporate form, had new authority to prevent municipal corporations from intervening to govern the business of private corporations, even when those activities violate residents' rights. We're familiar with that state of affairs today. To understand the implications of this two-part judicial revolution is to know the story of how the Federalists achieved a stupendous victory for wealth over commoners. The judiciary yoked the general population in every state to a central government, doling out privileges for the rich and disenfranchising all of us from democratic control of our local communities. Compounding this intolerable situation, private business corporations have been weaponized to invade municipal jurisdictions and exploit communities across the continent, backed by the U.S. Constitution's Commerce Clause and the Contracts Clause since the Dartmouth Counter-Revolution. Managers of for-profit business corporations, especially those engaged in interstate commerce, are in a superior position that allows them to treat municipalities like resource colonies. Nominal regulation legalizes their harmful extractive and monopolistic practices while lending a veneer of protective limitations on the damage they can inflict. The distinction the Federalists made between corporate privileged property and public state-owned municipal corporations not only emancipated the rich from democracy, but gave them a powerful tool with which to govern our communities in our place. Now, pause there. That's the end of the first section of the chapter. And it sets up really some of the elements of the story of all of our communities. So Grant Township is what we'll get into. But for instance, Heidi, in Virginia, in Buckingham County, where the folks don't want to have a gold mine, a huge gaping hole in the land, and all of the chemicals leaching out of it, all of the toxins leaching out of it. And you'd think in a government of the people, by the people, and for the people, that the people would be able to say, no, you can't do that to us. And there wouldn't be anyone to say, but you don't have a right to say that. And as we talked about, or we'll talk about again, when the revolutionaries decided to challenge the British Empire, and the Declaration of Independence was drafted based on the recommendations of 90 different local community governments, municipal and county governments in the colonies, sent their grievances to the Continental Congress and ask them to separate from the empire, the very first grievance mentioned in the Declaration of Independence, look it up, have a look at it. The second half of the Declaration is a list of, it's about almost 30 grievances, things that they were saying, here are the reasons why we need to separate. The very first one complains that he, the king, has disallowed our local laws that we have judged as communities, and this isn't, I'm not quoting, but laws that we have judged to be important to our daily functions. And the king has said, you can't do that. You can't make your own laws. You don't govern yourselves. Now, let's keep in mind, they weren't talking about state or federal laws. They weren't complaining that the empire was stopping the United States from doing anything, because there was no United States. It wasn't stopping any state from doing anything, because there were no states. It was stopping local, municipal, village, county governments, different sized local governments, from governing their own local affairs. That's the first reason for the revolution mentioned in the Declaration. And here we have, in the Dartmouth case in 1819, the Federalists, the folks who, when I mentioned that Joseph Story was a protege of Alexander Hamilton, Hamilton's the guy who brought a draft constitution to Philadelphia in 1787 that proposed a monarchy for the independent colonies. And that's where their heads were. And what they did in Dartmouth was to return the United States as closely as they dared to a system where the people did not have a right to self-government in their communities. Now, as an instance of how that plays out in the modern world, here in the 21st century, I'll talk about, the heading is called A Second-Class Township and Its Second-Class Citizens. Was there any questions before I move on the Dartmouth? Okay.
Kind of. The one part I got a little stuck trying to follow, where it was a contract. It went from contract laws, charter, and the public-private, and there was like this line that they went over, and I kind of got it, but what would be another piece?
The big line they went over is that when the king issued a charter to a corporation, so when Queen Elizabeth I created the British East India Corporation in 1600, it was a piece of paper, and it gave, it listed out certain privileges that the investors in that corporation would be allowed to engage in. But always the sovereign held on to the authority to revoke the corporation or to change the terms of the charter. Might have said, okay, British East India Company, you're really getting too powerful in India. And they really did get very powerful in India. The king or queen at the time could have said, okay, we are changing the charter and you no longer may operate in India. You can operate in these other places, but not there. And that would have been okay. That would have been legal under the terms of the charter as a grant of privilege from the sovereign. When Dartmouth trustees received the charter from the King of England in 1767, it was seen as a grant of privileges to the trustees. Now we have a revolution, and who are the sovereigns now? It's not the king, it's the people. And the people of New Hampshire specifically, because that's where Dartmouth is chartered, in New Hampshire. And so the people of New Hampshire have a right to revoke the charter and turn it into a private college. And the Supreme Court decided, no, we're going to change all that. All the history of corporations, from English common law, everything we've ever known about corporations up until this point, we're going to change it There's no precedent involved. We're making it up as we go along, and we're saying it's no longer a grant of privileges. Now it's a contract under the Constitution's contract clause. Now it's a contract between the people of the state of New Hampshire and the incorporators, in other words, the trustees of Dartmouth College. And the people of New Hampshire no longer have the authority to revoke the charter or to change it because they are parties to a contract. They aren't the sovereigns issuing privileges to the trustees. That's the big change. It's now a contract. And now it disempowers the people who issued it, the people of New Hampshire through their legislature, no longer the court has forfeited for them the authority to govern the corporations that they create because they're contracts.
I thought Dartmouth, I lived in New Hampshire, I thought it was a Ivy League private school.
It is.
Well, a lot of things have changed since then. So
Okay.
we're talking about up till 1819. Okay. So let me get on to unless there is, and did that clarify a bit, or are you still kind of in the dark on it?
Well, I'm curious, how did other schools fare? Like, you know, I'm in Charlottesville right now, home of Thomas Jefferson. How was UVA arranged?
Well,
University of Virginia.
the thing is that was arranged. I forget the founding of UVA, but I think it was after the Dartmouth case, and so it would have been set up where it was an issuance of a contract essentially, and so the Commonwealth of Virginia would not have authority to govern the actions of the state if it was set up as a private college, as a private university.
So
I have to admit, I don't know every college's charter and how they're set up, or whether they're private or public and the rest of it.
well, it's kind of more like, since Jefferson made a move to make it a public college, New Hampshire, wouldn't he also do that for Virginia? So just wondering if other colleges are follow along the lines of what he was thinking, because I mean, that's
We certainly have colleges. We certainly have colleges that are state run,
Yeah,
but we also have what are considered private colleges, private universities, and we have private corporations, business corporations, and so forth. But prior to Dartmouth, we did not. We didn't have those private corporations or private colleges because their charters could be altered or revoked. We can't go to Exxon and say, well, we do have laws that allow for the revocation of charters. The last time a corporate revocation was used in a quo warranto case, that's what they're called, quo warrantos. It was, I think, in the 1950s. There have been attempts. Matter of fact, CELDF has attempted to engage in that with a waste industry corporation, and the problem being it's chartered in Pennsylvania, and the only one who can bring a quo warranto lawsuit against a corporation in Pennsylvania is the Attorney General of the state. And the Attorney General of the state, at the time we tried to bring that lawsuit, his job prior to becoming Attorney General was as a lobbyist for the waste industry. So guess what? We didn't have a chance. There was no chance. All right, let's move on to second-class township and its second-class citizens. And I'm talking about Grant Township. And what they did back in 1819, defanging and taking away the democratic self-governing authority of municipalities and local governments, becomes obvious in the Grant Township case. So the Commonwealth of Pennsylvania classifies its municipalities as cities, boroughs, and townships, and it further categorizes them by class based on population. By far the most numerous types of municipalities in Pennsylvania are the second-class townships. According to the Pennsylvania State Association of Township Supervisors, townships account for 95% of the Commonwealth's land area and are home to 44% of its population. There are more than 1,400 townships of the second class in Pennsylvania. It should be no surprise that the people living in them are treated like second-class citizens. That's how the folk in Grant Township, Pennsylvania felt when a judge told them they have no authority to protect themselves against dangerous toxins a corporation called Pennsylvania General Energy planned to inject into the ground under their homes. In 2014, the people of Grant got wind of a spin-off money-saving project related to fracking. That's the extraction of natural gas by a process, and you know the process. It involves pumping a secret concoction of toxic chemicals deep into underground rock formations to crack them open and release the combustible vapors. When millions of gallons of the protected trade secret potion are pumped down under extreme pressure, what's loosened gets forced up and out. That includes methane and other fossil fuels, but also highly saturated brine, radioactive minerals, and gases, plus the toxins used to shatter the rock formation. The flowback waste is collected above ground. Disposing of it used to mean trucking it from Pennsylvania to Ohio, where the rules for pumping it back into the ground under high pressure were laxer than in Pennsylvania. The cost of transporting the waste out of the state cut into the profits of the mining corporations until industry lobbyists won the day and the Pennsylvania state legislature loosened its rules. The company eyed Little Grant Township, home to under 800 people, as the site for only the third injection well in the state. The families living in Grant depend on well water to survive. They'd heard about how the people in Dimock, Pennsylvania, and other towns in the Commonwealth had their clear drinking water turned into a dark brown smelly brew because of fracking. They didn't want that to happen in their township, so they enlisted CELDF's community rights organizer, Chad Nicholson, who worked with local community groups, the East Run Hellbender Society among them. By the way, it's named after a giant local salamander, the Hellbender. So they enlisted him and CELDF to draft what would elevate the rights of community members above corporate property and ban frack waste disposal within the municipality. So in other words, a local ordinance is what they asked for. In the summer of 2014, the township advertised the ordinance in advance of voting on its passage. The Board of Supervisors soon received a letter from the corporation's attorney threatening litigation that would ask the court for damages and legal costs if the ordinance was enacted. The threat didn't stop adoption of a community bill of rights that recognized the right of the people of Grant Township to clean air and water and a right of local community self-government to protect those rights. It also included a provision that CELDF has championed since 2006. It recognized legally enforceable rights for ecosystems. It was a decisive piece of legislation. The ordinance said it would be a violation of the people's and nature's rights for the company to site an injection well in the community. PGE Corporation hit Grand Township with a lawsuit that said the municipal corporation was violating the business corporation's civil rights. So the municipality that doesn't have self-governing authority is now violating the civil rights of the corporate person, PGE, that has a right, has, as a matter of fact, now constitutional rights. It also said the municipality had no legal authorization from the state to enact such a ban. It was a claim with roots in John Marshall and Joseph Story's creative invention of private corporations for the wealthy and public corporations for commoners. The people had no controlling interest in the municipal corporation, as did the owners and directors of PGE in theirs. When the lawsuit came, the municipal officials sent their legal representatives from CELDF to argue for the residents' right to protect their water, health, and environment with a local ban on the industrial threat. Then in October of 2015, Magistrate Judge Susan Paradise Baxter ruled on the case without considering the arguments that the CELDF attorneys were making. She overturned the parts of the ordinance that prohibited depositing oil and gas mining waste in the municipality and that subordinated so-called corporate rights to the unalienable rights of community residents. The rationalization for a judicial veto of these parts of the township's law was this. Under Pennsylvania law, Grant Township was a second-class township governed not by the people living in the municipality, but by a municipal code written by the state legislature and subject to absolute state control. The ruling said the municipal government that the people had elected to represent them has no legal authority to make or enforce governing decisions to protect the community without state permission. The best they could administer, at best, that is, they could administer nominal state regulations, but they couldn't prohibit what the state had permitted. The underlying message was that when the state issues a permit to legalize the use of privileged property cloaked in the trappings of a private corporation, the people may protest, but they can't prohibit the profitable violation of the community's rights. Grant Township is what community organizers call a sacrifice zone. What's sacrificed is health and safety and environmental sustainability, along with the democratic rights of the people. They're given over as rights vested in property and enjoyed by the owners of a wealthy corporation, with the complicity of a state that claims to own and control Grant Township and every other municipality within its borders. And I should add that this applies to every other state in the United States, because this Dartmouth ruling applies to all states and all municipalities. And even though it was in 1819, it was applied to Dartmouth and wasn't really activated and used in a lot of cases between 1819 and the end of the Civil War. But at that point, we'll get into Dillon's role, because that's when that comes in. And that's just a rehash of Joseph Story's Dartmouth sideline. So when the people of Grant Township and their municipal board of supervisors received Judge Baxter's decision, they weren't surprised. Not only were they expecting it, but they'd planned for it. Even before the court stripped their community rights ordinance down to its bare bones, the Hellbenders and their allies organized a campaign to change Grant Township from official status as a second-class township to a home rule municipality. Now, how did they already anticipate this? How did they know it was coming? That's the reason for reviewing this book. That's the reason for reviewing these laws and digging into history and understanding where all of this comes from. Because how can we create very strategic ways of dealing with these assaults on our communities if we don't know how to anticipate what's coming next? And because we could anticipate what was coming next, we were able to prepare for it and help the people of Grant Township to prepare for it. So going home rule was an option that would give us, if not a victory, at least more time. So going home rule would require, in Pennsylvania, electing what's called a government study commission made up of 7 community members. When elected, those 7 would constitute a kind of local constitutional convention charged with writing a home rule charter, the legal equivalent of a local constitution. They intended to write and adopt a local constitution rooted in unalienable rights. Now, even before the court rejected their local ordinance in October, as the Hellbenders and Grant supervisors anticipated it would, they had elected their study commission at the primary election in May of that year. Even before the ordinance was overturned, they had elected the government study commission at the primary election prior to that. Then in November, Less than 2 months after the judge's decision, the study commission proposed a charter that was placed on the ballot and adopted overwhelmingly by a vote of the people of Grant Township. So you see what happens. They had their ordinance stripped from them, and the immediately elected people who are going to sit down and write a local constitution for the municipality. Grant's legal counsel, that's us, CELDF, applied to the courts for dismissal of all complaints pertaining to the ordinance since it had been made moot with adoption of the Home Rule Charter. They did enact the Home Rule Charter that was written. And the court declined to act on this filing. So here we have a second class township and an ordinance that the court said you can't have it. And now we have a Home Rule Charter enacted by the people of Grant Township. So now we've replaced the second class township of Grant, and we now have a Home Rule municipality, a completely different corporate entity. And we asked the judge to say, well, that is the old ordinance and its revocation have nothing to do with the new government, the new system in Grant Township. And what did Judge Baxter do? She declined to act on that filing, just ignored it. Just ignored it. Judge Baxter's decision to protect the rights of the corporation against what she declared the municipality's unconstitutional ordinance was accompanied by notice of a jury trial to determine what damages and legal fees Grant Township would have to pay to PGE Corporation to make the corporation whole again. So not only can't you protect your drinking water, how dare you bring the corporation that's poisoning you and your kids to court, and now we're going to not only make you pay for their attorney's fees, we're going to make you pay for damages, some lost, business opportunities or whatever. Okay. So then the state went on the attack. So we have the judge in the form of the courts just blocking everything that the people in Grant wanted to do. And then with the judiciary busy representing the interests of PGE and the executive branch agency, that's in this case, the DEP, the Environmental Protection Agency of the state, they filed suit against the township. The DEP filed suit against the township.
Better known as Don't Expect Protection, DEP.
Right. Department of Everything Permitted. It's got a lot of names. Okay, so what's going on here? So the people, and they now have a new charter, a new local constitution that does actually the same thing, bans corporations from depositing frack waste in the ground in the township. And now we have the DEP filing a lawsuit against the township. It became a national story when the DEP sued Grant Township for protecting its environment more thoroughly than state law allows. The Department of Environmental Protection Agency, they are suing because Grant Township is trying to protect its environment too strictly. Sealing preemption raised its head. We'll talk about sealing preemption again. Sealing preemption. The suit argued that the ordinance illegally held DEP personnel liable for violating the community's rights when they issued permits to a corporation, thereby purporting to legalize the injection of poisons into the ground. And that's in opposition to the local charter. During the other litigation, a temporary settlement was reached with the agency when Grant agreed not to enforce that single provision of the ordinance against DEP employees. So there was an agreement. Okay, so we're not changing the charter, but we're not going to sue your employees for issuing the permits. We are declaring the permits illegal. They are illegal. And in that case, the DEP was considering backing away. Piling on, Judge Baxter agreed with a request by the PGE industrialists to sanction CELDF's attorneys who had argued the case for Grant Township. Baxter imposed monetary sanctions against the attorneys in the amount of $52,000. One of the attorneys was also referred to disciplinary board for the Bar Association for consideration of being disbarred. What lawyerly misbehavior was being sanctioned? Well, excuse me a second. Well, Judge Baxter said that the attorneys had repeatedly sought to vindicate the community's right of local self-government, despite the court's attorneys had repeated refusal to recognize it as a valid right. The judge also found it intolerable that the attorneys had repeatedly argued the legal rights bestowed on corporations could not be used to defeat the rights of the residents of the municipality. Judge Baxter claimed such arguments were frivolous and sanctionable. She agreed with the PGE legal team that CELDF lawyers should be fined and, if possible, disbarred for proposing such audacious legal theories. How crazy can you get? Saying that people can have the right to protect themselves against toxins. If we could put ourselves on mute, just if you're not speaking, that's background noise. So the legal doctrine that made it possible for the court to overturn the original Community Bill of Rights under the second-class township and then nullify parts of Grand Township's Home Rule Constitution was a spin-off of the Supreme Court's Dartmouth ruling. It was grounded in a legal theory based on Dartmouth that ignores the democratic rights of the residents of municipalities and champions the autonomous powers lodged in business corporations. The doctrine was developed after the Civil War to free a burgeoning industrial economy from the constraints of local law. And that rule is called Dillon's Rule, and we're going to get into that in part 6 in next month's section called the Municipal Colonies of America. Now, I'm going to stop there in terms of covering the text of the chapter and discuss things a little bit more here. There's certainly more to tell about Grand Township. That's as far as the story went at the time that How Wealth Rules was published in 2019. Since then, a lot has happened. So we're looking at, we're into this battle in Grand Township for 10 years now at this point. And we're leaving it off with the DEP having a lawsuit against Grand Township and them settling out and deciding not to pursue it further when they got an agreement that the township would not litigate against any DEP employees for issuing permits to PGE or any other corporation. Interestingly, the DEP eventually revoked the permit allowing the injection well to go forward. And so now we had PGE still in litigation against the township. The judge weighing and eventually imposing sanctions against CELDF attorneys for daring to advocate for the rights of the people of Grand Township and against the superior rights of corporations when you put them next to human rights and civil rights. That things looked like they were going to eventually have to settle out somewhere, and the courts were certainly not agreeing with the people of Grand Township. But the folks in Grant decided they would appeal. They've gone forward with another lawsuit, matter of fact, a federal lawsuit, suing PGE Corporation in federal courts for violations of rights, and or should say state court, Supreme Court. We have a constitutional provision that was enacted in the early 70s in Pennsylvania that recognizes the rights of the people to a healthy environment, clean air, water, and soil, and that the state, the Commonwealth, has the obligation to protect the public resources, the natural resources, into the future for future generations. And so that lawsuit, still active, as a matter of fact, keeps things moving. We also had, as I said, the DEP revoke the permit from PGE. So now it's almost, you would say, a moot point, that they would be prohibited from coming in, because without a permit they can't anyway, even by state law. But where things stand now is very interesting, because PGE Corporation decided they were going to throw in the towel. And this was just a few months back. They've already capped the well. So there was a well there for extracting gas, not using fracking in years past, but they were going to use that same wellhead to inject the frack waste into the ground. They have since capped it. Now, there's all kinds of ways to speculate about what happened. Why did they do that? Why did they throw in the towel? Well, after 10 years of litigation, maybe they're tired of their legal fees that they have to pay constantly. That's one possibility. The other is that they found that their wellhead was unstable, was leaking. And had they injected against the will of the people in Grand Township, I'm just speaking personally here, we can only speculate, but what might have happened had they injected that in to the ground and above the surface, above the level of the aquifers, there had been a leak. That means that the drinking water for the people of Grand Township would have been destroyed, just as they feared it might be. We still have yet to have a state court or a state agency or a corporation admit that this is a danger, that this is something that the people have a right to be concerned about and have absolute authority to protect themselves against. We have a corporation deciding to back away, to retreat, to say, no, we're not going to do this anymore. We don't have is an apology. What we don't have is even a statement of, well, we were wrong. We shouldn't have pushed you so hard. We shouldn't have cost you so much money. All of that stuff. No, there is never an admission of guilt, never an admission of wrongdoing. But what we do have is an end to the threat of poisons being pumped into the ground to poison the drinking water of Grand Township. That's where we are. But let's be clear. It wasn't the law that protected Grand Township. It was the people of the community. The people held out for 10 years, 10 long years of being called all kinds of nasty things, of being accused of not telling the truth. Well, you don't have the scientific proof to show that this will happen. You know, when it comes to self-government, there's no provision that says you have to have a scientific environmental study to support the decision of the people making those democratic decisions. It's a matter of discretion in a democracy. We don't always have all the answers or the absolute proof. It's a judgment call. That's what democracy is about. And people do make mistakes in a democracy and the decisions that are made. But we're not allowed to have democracy in the United States. And I would say that as a blanket statement. I'm one of those folks who believes that if you can't point on the map to a particular specific place where you have the authority of self-government, then you don't have it anywhere. If you don't have it in the place where you live, if you don't have local self-determination or community self-determination, then you don't have it anywhere. Because electing people chosen by two private corporate political parties, and that's not just a descriptor, the two major political parties are corporations, and they don't have to put in place the people that are elected by popular vote. They're the boss. They get to choose who their candidates are. We don't. And so that's not democracy, is what I'm getting, the point I'm making here. So What what ideas or what concepts kind of leave you wondering or not sure about something? And if you have something to say, you should unmute. And Hahnemann, welcome. Hello. And sorry you came in kind of towards the end of things here. It was really two stories that we told, or I told tonight from this chapter. The chapter is the one titled The Emancipation of Property from Democracy. And the two stories are about how it was that in 1819, the famous Dartmouth College case, there's a part of the decision led by Justice Joseph Story that actually is the source of the disempowerment of our communities, of our municipal and our county governments. And that goes for all states in the Union. Because in this decision, the Charter of Incorporation issued by states up until that point, and prior to the Revolution, issued by the sovereign, the king or the queen, those corporate charters were considered to be grants of privilege from the sovereign. What happened in 1819, to recap it, is that the court, especially with the arguments of Joseph Story, a staunch Federalist and really a monarchist, was to say that these charters are no longer grants of privileges from the sovereign, and the sovereign people of New Hampshire did not issue the charter to the trustees of Dartmouth College. And even if they had, this is now going to be not a grant of privilege, but a contract between the sovereign people of New Hampshire and the trustees of the college. And as a contract, neither party can unilaterally change the terms of the contract, revoke it, or affect its internal workings. And so the internal workings, that's the existence of the corporation itself. And so what the court said in the Dartmouth case, in Joseph Story's section of it, is that the corporations become kind of mini sovereignties when they're issued a charter. That once they have the charter, the state that issues them loses all authority and control over that charter. And now we have a self-governing private corporation. The other thing they did, recapping, is they invented a distinction between private and public corporations. Private corporations being the kind we understand as business corporations. They're the ones who receive a contract now following Dartmouth, a contract between the state and the incorporators. However, there's also a thing, Joseph Story said, called now a public corporation, and they include municipalities, counties, school boards, other kinds of municipal entities. And these public corporations do not have a contract with the state. This isn't a reciprocal agreement between the state and the municipality. It is instead just the invention of a subdivision of the state by the state, and the people living within the jurisdiction of the municipality have no authority to govern using that municipal government. It is empowered to do only those things that the state legislature specifically says that it can do. Now, in the Grand Township story, I mentioned home rule communities. And the difference between a home rule community and a public corporation of the municipal sort under the Dartmouth ruling is that rather than a municipality that can only engage in activities specifically enumerated by the state, a home rule community can do anything so long it is not specifically forbidden by the state. Do you catch the distinction? So before it became home rule, and as a second-class township, Grant Township could only do the things that the state specifically said it can do. And we never said you could ban injection wells, in other words. Okay, so that was why the court could simply say, we don't want to hear any other arguments. You never had the permission of the state to do this anyway. We're overturning your local law. Now they become a home rule community. And under home rule, the theory of government is you can do anything within, that isn't unconstitutional. You can do anything within the law so long as it is not explicitly forbidden by the state legislature. And so when they banned injection wells under their new home rule charter, the argument that the attorneys for the Township of Grant were making was, well, they have the authority to do this as a home rule community. What did Judge Baxter say? No, you don't. Don't want to get into that baloney. And not only that, I'm sanctioning you lawyers for daring to argue that the people of Grant Township have a right to self-government and that they have the authority to ban injection wells. I'm saying you can't, and now you just fork over the sanction money, and we're asking the State Bar Association to consider disbarment of one of your attorneys. That's the way the game is played. It's not beanbag, it's hardball. And it's also played with rules that really handicap the people, we the people, in favor of the privileges of wealth in the corporate form.
I got a question, Ben.
Sure.
Sort of a little complicated, but I'm thinking like the Green Amendment, Delaware River Keeper Network, I'm tied with them too. And so there are a couple states are trying to have that, New Mexico, Pennsylvania. Okay, so it's rights of nature kind of thing. And I know Lindsay was getting into that. And I've been to those classes too. It's tied with it. And I guess Heidi was trying to have that happen there. But you've got then the Colorado River, and they did the same sanctions thing. So how do you see it as a win, besides trying to educate people like you are right now? Because people don't know their rights and what they can't do. I think if people really knew it, they'd get out the pitchforks, right? So I guess just what do you think can happen to make things better for people? And the Murray Bookchin, I know you like Murray Bookchin. Does that have anything to do with it either?
No, Murray
Okay.
Bookchin and his municipalism doesn't come into any of this. I find some of his ideas intriguing, but I also find his thinking really kind of Byzantine, I guess. I don't know. But I will say that the Green Amendment is not a rights of nature amendment. It does not in any way recognize rights for ecosystems. The Green Amendment recognizes rights for people and communities. In Pennsylvania, we already have such a provision that was added to the state constitution. They refer to it as the Environmental Rights Amendment. And it's Article 1, Section 27 of the Constitution. So we don't need a Green Amendment in Pennsylvania because we already have one. And just for those who would argue that the Green Amendment is going to make all the difference, Pennsylvania has had a Green Amendment since it was included in the Constitution in 1868. And then there was legislation passed to activate that amendment in 1972, I believe it was. Since then, we have not had a renaissance of environmentalism. We haven't had any sudden uptick in the protection of environments. As a matter of fact, the Environmental Rights Amendment has been invoked in very few legal cases. And in the few that it has been invoked in, the courts haven't in any way recognized it or seen it as operative. So I'm not sure why we want to pour years and years of effort into passing green amendments. I'm not saying I'm not saying that that shouldn't be part of our law. I'm just saying if we want to change outcomes, it hasn't changed any outcomes. And Pennsylvania is one of the states, there are a few others. New York passed such an amendment just a year or two ago. And we haven't seen a renaissance of environmentalism and protective laws come about as a result there either. I'm not saying we shouldn't have that kind of language in place. But when you ask what's going to do it, the Dartmouth case, going all the way back to 1819, is still active today. And it was revitalized and repackaged as Dillon's rule, as a way to shut down democratic self-government at the local level. We have a lot of other provisions in the U.S. Constitution. Last time around, we talked about the Commerce Clause and how it affects our ability, actually creates our inability at the state and the local level to do anything that would interfere with interstate commerce. And the courts and the Congress can define as interstate commerce almost anything it wants to. Bird migration is a form of interstate commerce. Did you know that? Why? Well, they cross state lines, right? Mm-hmm. Pollution is a matter of interstate commerce because it crosses state lines. The transportation of waste is interstate commerce. Well, we never thought of it as a commodity up until the 1990s when the Supreme Court said, well, it is now. So now states can't say, no, we don't want waste imported into our landfills from out of state. It's unconstitutional for states to refuse waste from every other state in the union or any other country. You have to take it because it's commerce.
I have a question. I put it in the chat. What did Andrew Jackson do that upset the Federalists? And how did he encroach on their privileged property?
Well, I'm not going to spend too much time on Andrew Jackson tonight, but he was
real quick.
He was what we might consider a kind of a populist president. He tried to appeal to the common people, and that never settles well with people of privilege and wealth. And many of his actions seemed to go in a direction that was not favored by the corporate folks, by the wealthy folks. So he was not.
He offended them, not necessarily did anything in particular.
Oh, he did lots of things in particular, but we just don't have time to go through all of that. But was he a genuine representative of the common people, the working class? I would argue that's not a good characterization either.
Wow.
Our past president, who's now under indictment, liked to invoke Andrew Jackson as kind of his patron saint, which kind of makes sense that he would want to attach his reputation to Andrew Jackson because he wanted to be seen by, the blue collar workers and regular working folks as really on their side. And gee, just wasn't Jackson too? That's a whole nother thing. And I'd say pick up a story of Jackson's presidency, and there's lots of history books out there, but and you never know which one's going to have what bias or not, unless you get into kind of looking at the historians and what their particular take on history was. But you can get a pretty good sense of why Andrew Jackson was not beloved by the kind of
the ruling class.
With the ruling class, the upper class. He was kind of a loose cannon in their eyes. They couldn't control him as easily as they could other folks, and so that was not good for their interests.
I'm sure they liked the Trail of Tears.
Well, some things they liked, I'm sure, because Andrew Jackson wouldn't have been in for very long. There would have been a way to get him out if he had gone too far in displeasing the folks who actually pull the strings. So, this chapter and the discussion on it is a little bit shorter, actually, which just means we're going to end on time for a change.